This is the first in the series of the Managing IP Disputes, Decisions that Drive Outcomes, Insights for Corporate Counsel 5-part webinar series that Procopio is putting together in conjunction with our incredible partners at the San Diego chapter of the Association of Corporate Counsel. Presenting today, this panel is about managing IP litigation from first threat to final resolution. Essentially, this webinar is going to present an overall view of the entire litigation, and some of the subsequent webinars in the series will dive into specific parts of the litigation or issues that you frequently see in IP cases in more depth. And if you're interested in any of those subsequent webinars, there's a slide at the end that has the dates and a little bit more information about those that we can leave up. With me presenting today is my partner, Mindy Morton. I'm Ben Herbert. We both are partners at Procopio. Mindy is up in the Silicon Valley office, and I'm down in Irvine. And then joining us is Katie O'Sullivan. And Katie, why don't you tell everyone a little bit about yourself?
Sure. Hi, everybody. I'm Katie O'Sullivan. I started out as an IP litigator in Big Law. I went in-house about 4 years ago. Now I am senior corporate counsel and I head U.S. litigation for Renesas Electronics, which is a large Japanese semiconductor manufacturer.
Katie, do you want to say the disclaimer for yourself?
Sure. Just since I'm the in-house panelist, I will just note that every opinion and viewpoint I give here is my own and not that of my company's.
Okay, here's the overall agenda for the webinar today. We plan to go about 55 minutes and reserving a couple of minutes at the end for questions. But if at any point in time during the presentation you have a question, feel free to unmute yourself and just ask. Otherwise, please keep yourself muted so we don't have any background noise. Why does this matter? Why are we focusing on having an overall strategy at the outset of the litigation? Well, having that type of strategy matters because early decisions often determine cost, leverage, and ultimate outcome of any dispute. Early missteps can have a material effect on the litigation, the cost, or the risk associated with it. And in addition, you need to have a legal strategy that aligns with your business goals. And trying to put that together halfway through the litigation is usually a recipe for not getting alignment there. And what are some examples of how some early missteps can be difficult to unwind or materially limit your options? Well, if you consider a trade secret misappropriation matter, if you're a plaintiff side on that case, if you don't sort of initially know that it's something you want to move for a preliminary injunction on, you can take a bunch of time investigating or communicating with the other side, and it can go months and months. And then if you suddenly file a complaint, the likelihood of you being able to get a preliminary injunction has been dramatically decreased by the delay from when you first found out about it to filing the complaint and then seeking a preliminary injunction. So that's just one example of how if you don't sort of have your ducks in the row from the outset, it can really implicate the overall strategy. So, Katie, how do you ensure that your legal strategy is aligned with your company's business goals sort of at the outset?
I mean, at the outset, the first thing you need to do is actually figure out what your company's goals are. And I think that in-house, this is kind of a tricky thing, right? Because you have different stakeholders. So depending on who you're talking to, the goals might be different. Like you have a sales manager, he wants a customer. You have another level up from that who's worried about something else. C-suite's worried about reputational impacts, things like that. So there are actually like multiple objectives going on. And the first thing you need to do is figure out, okay, like what is the overarching objective that we want to accomplish in this litigation or this matter? And so I think first step is like, what is your business goal, right? And like, if there's multiple goals here, like how do you synthesize those together so you have kind of like one path to move forward?
And when you're coming up with the sort of initial IP strategy or helping him help come up with the overall IP strategy for the company, and sort of what the mix of patents, trade secrets, or that is, copyrights, trademarks, that type of stuff. Are you when you're making that strategy trying to think down the road about potential enforcement and when you're making that strategy and trying to determine what the mix should be?
Uh, yes, I will say just like based off my technology area, it's not super difficult. Like we don't see a lot of trademark and copyright issues. It's, primarily like patent issues just because we're, hardware. So I think if you had more of a mix, that would be different. But it definitely does come into play like when we do prosecution, build our portfolio as you're thinking about you know, kind of all those things like offensive, defensive litigation strategies, like they all go into play when you're building out your ultimate IP portfolio.
As I mentioned earlier, this is the first webinar in a series of five. We're going to be talking about sort of the overarching from first initial sense that there's a threat all the way through trial or potential settlement, and subsequent presentations will talk about different aspects. Okay, let's dive right in and sort of just talk about what the IP dispute life cycle is like, at a high level.
Sure. So the reason we begin here is that most companies think that IP litigation is a single event. You get sued, you defend, or you sue and then, the other side defends. But it's actually a series of connected phases, and each of them have their own decision points, own risks, own cost profiles. So kind of understanding the shape of the litigation life cycle, that allows you to anticipate what's coming, and it can allow you to position your company strategically and appropriately at each of these stages. Um, Thinking a little bit about the life cycle overview. So we've broken it down into four basic phases, beginning when the threat triggers an internal assessment. That's where the clock starts running. And that's honestly where you, especially if you're the plaintiff, have the most control. Then we get into the strategy phase, and that's where you kind of start thinking about how you're going to present it, what forum it's going to be in, what your objectives are. And if the matter proceeds past that, that's when we file a litigation, or a litigation gets filed against your company. And that's where, it's really important to be strategic about costs and how to position yourself within the lawsuit. And finally, resolution. And that's not just the legal outcome, but it's also, what the priorities are for the business. So what we'd like you to take from this is that each of these four phases is very distinct, and you have to have a different kind of focus. And what you do in each phase really impacts how the next phase unwinds and develops. So it's really important to think strategically and critically, and not just rush into doing something. Again, whether you're defense or plaintiff. Okay. Um, so outcomes at litigation are almost never decided at trial. I think this is one of the most important messages that we might have here. They're often decided before the case is even filed. And that's when you have kind of the flexibility to have creative solutions. So thinking first about before filing, Katie, what are some of the most common internal challenges that in-house counsel might face in those first few days pre-filing?
Okay, so I have to preface it that I'm almost always on the defense. So we get sued a lot. We don't tend to sue people. So let's talk about it as far as like a complaint is filed. It's a different set of considerations if it's like a pre-suit negotiation. But like if I have a complaint get filed, I mean, the first thing I'm going to do is kind of like get my ducks in a row, right? Like calendar my deadlines, get my lit hold in place, get outside counsel, get my internal stakeholder team together. Those are like the things I'm going to do. Now, the most common challenges I see when doing that would be lit hold. It's always a question of who gets included, how wide is your scope? Like that's just kind of an administrative thing. But it also goes back to like you need to understand what the dispute is and like who's impacted, like which business area, which employees. And then the second one is the RFP process for your outside counsel. To really have an effective RFP process, you need to understand like the scale and size of the dispute. So I think my take-home message is if you're in-house counsel, the best thing you can do is to really understand what this dispute is as soon as possible. Like go get your facts, go find your relevant employees, like try to figure out what it is you're dealing with. And if it's something you haven't seen before, then like go find counsel who knows what this is and can help you. But a lot of times we see the same type of cases over and over. And so we start getting a sense for what this is, the size of the case, the kind of support we need. And you just kind of like move forward from there. But I will say, as far as like on the defense, you have a complaint filed. Those are like the common roadblocks I see. Those can be resolved if you just go and immediately start doing your homework on like what this dispute is.
Yeah, and that's Katie, that's a really important point because the investment that you make at the front end of that case, and again, whether it's on the offense or defense, that really pays off. The early assessment, the strategy, the alignment, that can really significantly determine your likelihood of success, whatever that means in the context of the case, and also controlling costs.
Yes.
And as an outside counsel, when I look at these three kind of stages, for me, these are the inflection points where settlement or is a possibility, or a mediation might be more successful. And especially, I know Katie, you do more patent work, but I do a lot of trade secret work, and a lot of times in trade secret cases, you have, I think, about 85% of them involve departing employees these days, based on the latest stats. And there's quite often the new company to which the departing employee ends up is also included, or at least a demand letter sent to them. And whether you're the trade secret owner or that potential company who's targeted, there's a golden opportunity before any complaint is filed to try to resolve the case quickly and easily. Because trade secret cases especially get very expensive at the beginning of the case once the case is filed. And so if you are a target of a trade secret case or a trade secret demand letter, you need to get moving very quickly. And we'll talk more about kind of some of the things you can do, but you really do have a golden opportunity there.
And I'll say, I think that those are great points. All this, I could not agree more that all of the early work that you're doing is essentially like compounding interest, and you really can see the value of it down the road. And just one additional point I would say, despite the fact that a tiny percentages of cases that are actually filed go to trial. I think it's incredibly important to litigate all cases like they're going to go to trial, because I think that that is the way, doing it that way is the way you can preserve the best sort of optionality for resolution and leverage for resolution. If you're sort of going into the case and litigating as, oh, all we want to do is litigate this to get a settlement, I've just seen that go sideways a number of times. And, you might get a settlement, but the terms are probably not as good as if you had, taken it really seriously and said, well, we're going to litigate this as if we're going to trial, because that, I think, puts you in the best position to sort of take an off ramp prior to trial.
I agree with that. I think, Ben, there's one caveat though. And again, in trade secret cases, and this is kind of a mini trial, but I think you should litigate it as if the preliminary injunction is the most important part of the case, assuming you're seeking injunctive relief. Because a very high percentage of trade secret cases end there. And obviously there's a lot you can do after if it's continuing trial, but your focus should really be, if you were the trade secret owner, on getting that preliminary injunction.
100% agreed. Okay. So let's break that down and just sort of start. We talked about the initial demand and that sort of thing. Let's just now focus exactly on, well, when did these things actually start? And here are the most common types of IP threats and sort of how they rear their heads. We have demand letters, licensing assertions, trade secret disputes arising from employee movement, and then platform or content disputes involving copyright or brand usage. Now, I know, Mindy, when we were preparing for this, you talked a little bit about demand letters concerning privacy issues. How should folks be, and I know that's something you do a lot of, how should folks be thinking about handling those?
Yeah, so those, what we're finding, so I'm guessing a lot of you have been lucky enough, and I use lucky, not in the traditional sense, to get some demand letters from a number of the plaintiffs' firms in California or elsewhere in the country, but they're mostly coming out of California, alleging wiretapping, or California, it's SEPA, because you're using cookies on your website. Um, and what we're finding is that once one of those is publicly filed, there's a whole lot of other um, plaintiffs firms that are smaller and maybe not as experienced, and even some prolific pro se filers who then do a follow-on complaint. So there is if that demand letter is seeking a complaint in court, there is a strategic advantage to settling that before it's filed because you can avoid some of those follow-ons. If it's an arbitration demand, that's a little bit different because it's not public, but definitely make sure you're paying attention to those timelines because I've seen clients who have, they don't really mean it, and suddenly they're faced with 4, 5, and 6 of these demand letters once it's filed publicly.
Great. Now, Katie, let me ask you this because I think that you internally handle demand letters related to patents just a little bit differently, and I think a lot of work is being done by you all internally. Can you just talk a little bit about how you guys respond when you receive a demand letter and how it's potentially a little bit different than a lot of other companies?
I mean, I think the benefit I have at my company that a lot of others don't is we have like a pretty robust like patent defense team, and that's because we have like a robust prosecution team. So like we're really able to analyze demand letters when they come in. Like we can do like a full analysis of non-infringement and validity in-house. And I think that that is what sets us up for success. And we are really successful at getting rid of demands ourselves without involving outside counsel. And I think it's because we're able to do that work, right? And I mean, going back to what we said before, like we're putting in the work like immediately. Like we do 90% of a case, before a first motion is filed. And I cannot tell you how beneficial that is to know the strengths of your case, to know where you're going to go even if it doesn't get litigated for settlement opportunities and the like you have the numbers. It just makes everything so much easier when you go in and you do that work. And so again, I'm really lucky in that I have that team in place that can kind of run those analyses in-house. But I think that's the way that we've been so successful.
That's really interesting, and I do think that it's different than what a lot of people are doing or are capable of doing. Let me ask you this, and I think a lot of the people on the webinar have patent backgrounds. So
Mhm.
I'll just quickly touch on, there have been significant changes at the PTO with the new director with Squires, and specifically with sort of the policy changes that he's implemented around IPRs and the ability to get IPRs instituted at the PTAB. Have you seen, as a result of those changes, have you seen an increase in any types of IP threats based on that?
Yes. So, and for those who don't know, the major changes of the PTAB is it's very difficult to get an IPR instituted now, whereas before, I think it was around like a 70% chance. Ben, you can correct me if I'm wrong. About 70% chance you would get an IPR instituted. And that was a huge lever if you're a patent challenger because you have now a parallel proceeding. The invalidation rate of IPRs was pretty high, so it was a very good tool to use if you're a defendant. Now IPRs are essentially off the table. Some defendants are looking at re-exams as kind of a alternative. That's like a whole different talk, but it's looking like Squires is also trying to get rid of re-exams or like narrow it down. So what this is leading to, and I've seen, I mean, I can speak from what I see. I can only speculate as to the industry as a whole. But like if I'm an NP and I have a giant portfolio of patents, before this happened, I would only pick the patents that I knew I could defend in an IPR, right? Like my strongest patents to go assert. I would go do those in a demand letter and a follow-on litigation, if the demand letter was unsuccessful. Now I can go with the weaker patents that I might just roll the dice, at a district court trial on validity and non-infringement, because typically district courts are a little easier to get over than IPRs. IPRs are patent judges or experts in the field, whereas a district court judge and a jury might not be. So I think you're seeing an increase because these entities are now going back to their patent portfolios, looking at the patents they thought were the weaker of the bunch and reasserting those.
Yeah, and I think although the PTO has sort of indicated that its preference is for people to be moving for post-grant review PGRs, the reality is that even to patents that's applicable to, it's only applicable for the first year of the issuance of the patents. And I think the strategy that you've seen sort of coming out is people will just wait for a year and then assert the patent so that the PGR window is closed to the extent it's a patent that PGR even applies to.
From what I see too is when like a non-patent entity, like an assertion entity buys a portfolio, they tend to buy older patents because they are cheaper. So they will buy a portfolio of older patents. So those are out of the PGR realm to begin with.
Okay, so you've gotten a demand letter or a sort of a threat, an IP threat has come up from, from any source. If you're a plaintiff side in a trade secret, it could just be you've some employee comes or some current employee comes in and say, hey, so and so just left and went to our key competitor. Something like that comes up. What should you be doing in the first 72 hours? Now, I think this is a little bit akin to the first 48 hours in a criminal investigation. Everybody knows that that's sort of, if you don't figure it out by then, the chance of it getting resolved is dramatically less. And it's sort of, it's not that bad, but the first 72 hours are really important. And so what should you be doing? First thing, you should be implementing a litigation hold as soon as humanly possible. I cannot tell you the number of times I've litigated cases and one side has had evidence go missing and there has been spoliation motions, which increases costs. And then there's also been preclusive orders based on findings of spoliation. And that can just dramatically impact your case and it can be really detrimental. And so making sure that that doesn't happen should be, one of the first things you do.
Ben, on along those same lines, and again, if it's in a dispute involving an employee, if the employee is leaving your company, you should make sure you're preserving anything to do with their computer. And honestly, this is probably pre 72 hours, but if it's an important employee, just copy their computer and everything else that it's not a lot of data anymore, just in case you need it. You don't have to hold it forever, but that kind of preservation goes beyond what we put in a lit hold. So that's something that's really important, especially in trade secret cases.
Yeah, and I'll say on that, listen, I've had two different occasions where one of my clients has essentially said, "Oh, the computer was wiped as part of the person leaving," and then we've asked them to, "Can you actually just go back and check and make sure that the IT department did that?" And the response comes back, "Oh, it's just been sitting on a shelf that never happened." So, which is great, which is what you're hoping to happen. But I would say even if that falls through the crack, double check with your ID department that sort of the policy of wiping the computer actually happened because a lot of times they're backed up and it never happened. So just always practice tip, always double check that. The other key things you really want to get your sort of your stakeholders identified and your ducks in a row about, who are the people that know what went on, and get everyone aligned on that. And the last two are sort of controlling communications and avoiding premature responses. Those are closely tied together. As Mindy and Katie were mentioning earlier, you really want to make sure that you've analyzed what's going on and have a really firm grasp on the situation before you allow people to go out and start communicating with potentially opposing counsel or opposing parties about this dispute, because it can be hard to walk back incorrect things that were said, and you just don't want to be in that situation.
Yeah, and Ben, and Katie, I don't know I know you mostly deal with patent, but in-house counsel has a really important role to play here because if this is involving employees, you're going to be advising the business on whether they should be, asked to stop working or stop connecting to the system, at least while this is initially pending. And you have to, really identify those key issues and implement them quickly.
I could not agree with that more, and especially on the making the decision about what you're gonna if you're the company that has the new employee and there's an allegation that that person has taken trade secrets. This question about what you should be doing to that employee and what they should be having access to is incredibly important. And I've, you know, if the plaintiff can prove that the trade secrets got into your company, you're going to be facing a battle of trying to prove the negative of, oh, well, the stuff got into our company, but we never used it. That's really hard to do. And what I've seen happen a ton is, a company will make an initial determination of, oh, we don't think there's an issue. This person can keep working. And then that'll go on for a month and a half, and some more information will come out. And then they'll sort of take another half measure and be like, oh, well, they're just not going to attend meetings about this. And then, 3 or 4 months go on. And then suddenly it's, oh, we're putting the person, on essentially garden leave. They're not doing anything, yada, yada, yada. The problem is that whole entire time you've just been building this story that you're kind of not taking it seriously, and you're providing sort of windows where this stuff could have been used, and you really have to think about, with the amount of risk with punitive damages and the apparent ease with which you can get them if you got the right facts in a trade secret case from a jury, you really need to be thinking up front, can we even take the risk, or should we really just implement a full measure immediately and put ourselves in the better position, rather than, potentially risking a verdict of hundreds of millions of dollars. But Katie, how are you dealing with this on the front lines in-house when you get a demand letter this first 72 hours? And what are you focusing on?
A couple of things. First, since we're talking about trade secrets, we do see this, and I think you've both hit on it. But I think a takeaway point for our in-house folks is you need to be really good friends with your IT department and your HR department. Like, one of the first things I did when I went in was I sat down with HR and I was like, what are our policies for incoming employees and exiting employees, and how are they followed? Right. So, like, if you have incoming employees, you should be reminding them not to take documents from their former employer. Make them sign a declaration that says they didn't do that. When there's exiting employees, you should get their devices, right? Like Mindy and Ben said, like, get their devices. And if you flag them as someone who's going to a competitor, someone who just did some suspect things, like, make sure you have those devices in hand. IT knows where they're at. And talk to your IT department about what capabilities you have in-house, what you don't, so you know about this. But, like, you should really have a trade secret type plan in place that involves both your IT and your HR departments, so that you can move quickly when something happens. So I will say that on the trade secret side. On any type of like a dispute or a complaint, I think a big thing that needs to be done, is this goes to like controlling the internal communications, is really getting in front of the business folks who are involved in that dispute. And what I'll do is I'll immediately set up a call with like any of the major decision makers or people who have contact with that other party, if there is any. And I'll set up a call and I will basically give them a rundown of, this is what attorney-client privilege is. This is what should go in written communication. This is when you should call me. And I have this whole speech about, like, you're in pre-dispute land. Now you're in dispute land. Like, this is how we operate here. This is how we operate here. And, like, if there's a very contentious like dispute going on, we're not quite in litigation yet, I will be like, okay, I need you to send me any written communications before they go out. I just want to see what's going out. And it's just so I'm aware, right? And I can help shape that narrative, make sure we're not saying things that are going to later pop up on a screen in front of a jury, right? That we don't want to say. So I think in that first 72 hours, it's getting involved, right? Like, and making sure you know the stakeholders, you can talk to them, give them attorney-client privilege cautions, just kind of put yourself in there. And I think the easiest way to do this when you're in-house is really just offer yourself as a resource, right? Like, a lot of people get super freaked out. Like, they're freaked out. They just got sued. There's a big litigation coming. Come in and say, I'm here to help. I'm going to shepherd you through this. Like, here's the 5 things we're going to do, right? Like, bing, bang, boom. And that usually helps calm everybody down. It gets you kind of a seat in the room, gets you in control of the situation.
I think that that's all incredible advice. And the one thing that I would add to when you're onboarding new employees or exiting employees or leaving, I would also just ask them to run a search in their personal email for
Oh, yeah.
the company's email domain. And the number of times that people just inadvertently have an email from their prior company that got copied on their personal email account by accident or something like that, it almost always happens. I think it's worth having those people check and just make sure they don't have anything there too, because that can be inadvertent, and you don't want it to come and bite you down the road. So it's worth checking. Okay. So what are some of the early mistakes to avoid? And I think we covered a lot of these in what we have just discussing, so we don't need to really belabor the point, I don't think. Um, you know, Mindy, you talked a little bit about in the privacy context about how the early involvement of counsel can really be helpful to avoid some missteps or potentially dramatically reduce litigation. Like, what do you think people should be doing if they're getting an early privacy demand?
So a couple things. One, take it seriously. Don't just, put it on your desk and forget about it because they almost always have deadlines. But two, take a really careful look at your website because these are almost all about websites these days. Um, and figure out what cookies you're using or tracking devices or pixels or whatever else. And A, make sure you want them at they're actually you know, have a business purpose. And B, figure out probably a better way to configure them because if one plaintiff's firm has found you based on the cookies, more will. So that's your opportunity to do your best in consultation with your IT and experienced privacy counsel to kind of make some fixes to hopefully stave off future demands.
And Katie, I know that you already talked about the importance of open communication and how that can help you avoid these early mistakes and being a counselor and laying out the options to, business people potentially that are stressed out. Um, but I wanted to turn back and just ask you quickly. Earlier, you were discussing the analysis that you guys are doing internally when one of these letters comes in. Is that something that you're doing as sort of a one-off just for that litigation, or are you leveraging any of that analysis for subsequent decisions that might help avoid early mistakes down the road?
Um, both. So, the analysis is done, and at least in, our field, we see a lot of repeat players. So like it's the same portfolios getting asserted over and over by the same people. So that analysis tends to just be useful down the road. I'll also say I have the benefit of a couple of team members who have been with the company for like over 20 years. And so we just like history just repeats itself. Like you see the same people asserting the same demand letters. It didn't work out 5 years ago. They try again. And we just keep really detailed notes, right? Of like when letters come in, and we can just reference that. And I think that is like something important to do, like when you get these letters and whatnot, is to just make sure you have some type of someone's at least tracking it, right? Like there's someone with knowledge of what happened. And that's written down in a way that like the rest of your legal team can understand because it's just going to save you time when it happens again.
Great. So we've talked about the first 72 hours, how important it is, and what you need to be doing, and who you need to be talking to, and facts you need to be gathering. Why are we saying you need to do that? What's the point? Well, here's the point. The point is so you can make an early case assessment as soon as possible. Um, and the reason you want to do that is without that early case assessment, it's really much more complicated in determining what you should be doing with this given demand or potential litigation that you have if you're the plaintiff. Should you be pursuing it? Should you be trying to do early settlement prior to trial? If you don't have the assessment, it becomes a lot more difficult to to figure out what you need to be doing and keeping all your options open. So in terms of timing, Katie, what's your goal in terms of the early cases settlement and having that analyzed as it relates to the sort of overall litigation timeline?
I mean, I want to know my case assessment as soon as humanly possible, right? And you're not obviously going to know everything, but you should know as much as you can know as soon as you can know, right? Or as soon as you can know it. So if I'm the defendant, I'll go do, my invalidity, my non-infringement analysis, look for any history between the parties, sales data, all of those things. So I have as many data points as possible as early as possible. Now, obviously, that will, change as the case goes along. But without knowing that, like, I don't know how you form a good strategy down the road. Like you don't know if like a 12b6 is appropriate or like if some other type of early motion is right. You don't want to do something in your answer or miss a motion because you didn't do that work up front. So again, it's just be proactive, not reactive. So go out and like learn your case as fast as you can.
So you have the early case assessment and well, what's next? Well, what's next is deciding what your ultimate strategy is going to be. And I'll say here, this is a point that Mindy, Katie, and I discussed when we were preparing for this. Don't be limited, and I don't think in-house people do this, but outside counsel sometimes do this. Don't be limited in the potentials strategies as being limited to litigation. There are business strategies that you can use. And if you're working with your in-house counsel and the in-house counsel is working with their business people, like, the person that sent you the demand very well could be a consumer of your products that is looking to renew a contract in a year and a half or something like that. And so that might be a leverage point of, well, this person wants this renewal. Maybe we can loop the renewal in or do something there that will help resolve this fight that we're having now. And so don't myopically, and again, I think this is outside counsel sometimes is does this. So don't myopically being saying, well, our options are litigate or not litigate or and kick the can down the road and see what happens. Really understand the client's business and other potential options. Um, so, Katie, let me ask you this. Um, when when are you trying to involve the relevant business people in this decision about what we should be doing?
Immediately. So the the people from the product group or whoever is affected, those should be in your internal stakeholder group, right? Like the people who have any contact with the opposing party. If there's business levers to pull, you should find them like as soon as possible because that's going to influence early settlement discussions. And if you have something, right, like if there is a lever there, you can just get rid of this before the case even begins. Like, and we find that a lot, right? And I think it's up to you to find the business to see if there are ulterior motives behind whatever's being filed. Because a lot of times there are, like you said, Ben, like they're trying to get business or they're mad about something or this was a dispute over something else and they're using this as leverage. And so it's like understanding if there's other motives, if there's other levers you can pull, like that should be in the first analysis, with all of the traditional like legal analyses you're doing.
Great. Okay, so how does the strategy that you've come around to, how do you implement that throughout the litigation?
Yeah, and so this is really where you're going to determine the trajectory of the entire case, or potentially not a case, right? But you know, none of these issues that we're going to talk about are mechanical choices. You have to have judgment, and you have to have alignment between the legal team and the business, and between the company and outside counsel. And what Ben was saying earlier was, that sometimes outside counsel can be a little focused on litigation. It's really important for outside counsel to understand the business and to understand the business justifications for why things happen. And that doesn't happen, the second that you are hired through an RFP. It's important to develop and to really learn your clients' businesses and what their approach towards risk is. And that all, again, has to happen before any of this starts. So, just think about that. But thinking about offensive versus defensive strategy, this is, again, an offensive posture like use of a declaratory judgment action, you get choice over timing and forum, and that's valuable because where a case is filed and when it starts can make a huge difference. Being on a defensive posture, that may be more comfortable. You may not have yet the legal justification for going more on the offense, but that means you're reacting as opposing to being proactive. And you know, personally, and it depends on the situation, but I prefer to control as much as I can on behalf of my clients. Um, that's not always possible, but you know, just don't. I think a lot of companies default to a defensive posture because they think it's cheaper. And it may be immediately cheaper, but it may be a lot more expensive in the long run. You could, if you're a California-based company, you could find yourself defending a case in Texas or Delaware or somewhere else where you might have been able to control the forum um, if you had filed offensively. But but Katie, I know that you've said that you're often on the defense side. How do you try to maximize the benefits, knowing that you're most likely going to be the defendant in these kind of cases?
And I will say, like the few times I've been on the offense, I feel like strategy is way more fun because you get to think about more. So it's different though. Like it feels like you're being more creative when you're on the plaintiff side. You're like, I could do this or this, and this could happen. Whereas defense, you're like, I have these four options. Here are my likely outcomes. So, but I will say, on the defendant side, like it is comfortable, like you said, like you're responding. But I think the biggest thing is to still be proactive in it. Like I think even as a defendant, you can be really proactive in a strategy, and your strategy will often involve like settlement levers or pressures. Um, and I think, I don't know, if you're not a litigator and you don't come to this, you might think of it as like, okay, the business decides whether or not to settle or litigate. And if we decide to litigate, we're going to litigate and then something's going to happen. When in reality, that is not how it happens, right? Like that should not be how it happens. In reality, you have your facts at the beginning, and it's going to make sense to either settle or litigate. And then you're going to continue doing that exact same calculus, settle, litigate, settle, litigate, settle, litigate, settle, litigate, all the way to the end, right? And along the way, you're gathering more facts about your risk tolerance and what the likely outcome of the case is. And so by the time you get to trial, you should have a pretty good idea of where this is going to go. And if you don't, it could just be a weird case, or you weren't paying attention, or something strange. But it's not like this one-off decision. And so I think even on the defense, you are making proactive choices the whole way down, right? Of like, how do I, you know, put this posture more on me, right? And maybe the answer is we don't want to settle for various reasons, and we do want to litigate to set a precedent, something along those lines. And it's like, okay, I know that that is my goal. How do I set myself up to obtain that goal at the end? So sorry, I don't know if I answered the question at all, but that's how
Oh, I think you did. And look, I mean, I think another thing, an interesting thing about being the defense is, you know, to some extent, you don't necessarily, depending on what the other side is and how reasonable or unreasonable they're being, you may not have as much control over settlement, right? You may want to settle, and that may be strategically the best move for your company, but they may be being unreasonable. And so then you have to kind of factor that into the analysis. I had a case that settled last month, and the attorney that was assigned to this case on the plaintiff's side was demanding something outrageous. Like I could have tried the case for less. And so, my client wanted to settle. They didn't want to be embroiled in this. And, sometimes interesting things happen. That associate attorney, unfortunately, was fired. And the person who took it over was much more reasonable, and we resolved it that day, literally that day. So, you know, be prepared and kind of pay attention to what's going on. And sometimes, these things are kind of unexpectedly thrown in, and take advantage of them, right?
And I will say, if you have like someone who's really unreasonable on the other side, always think about like alternate dispute resolution provisions. I feel like that's really helpful if you have one side who's like way off in left field, is to bring in like some third party. But anyway, I can do like a whole other talk on that. But like that is
We
one
could.
thing. Yes, I would recommend if you have someone who's like just super emotional, will not give you anything.
Absolutely. Ben, can you go to the next slide?
Yep.
So here's some of the strategic decisions that you're going to be faced with. The first one is likely, once there's a lawsuit coming down the pike, is forum. And that's state, geographical, and it's also federal or state, because remember, trade secret cases in particular can be filed in state or federal. And I would say pre-COVID, when I was a plaintiff in a trade secret case, I would quite often file in state court in California because I could go into court at 8:15 and walk out with a TRO at 9 a.m. That is not the case anymore in state or federal court in California. You often have to reserve your TRO hearing, and it might be a week out, and you have to take that into account. But know the local rules of where you want to file and know how long it's going to take to get that immediate interim relief if that's something you're going for. Katie, what are you thinking about on these forum strategy questions, especially given kind of what's going on with the PTAB?
I mean, in the very rare cases I get to be offensive. I mean, it's all just about what it is your end goal is and like what forum makes sense for that. So like you said, with state versus federal and trade secrets, like, do I want to get a TRO? Like, what's the point of my litigation? Pick the forum that makes sense. I mean, as far as PTAB, like as a defendant, like it's just largely not available. Like, so I need to figure out like, okay, I got to put my resources in the district court case. Is there a way to, if I'm in an unfavorable district court, do I have some way to get out of there? Like, do I want to try a DJ or a motion to transfer or something of the like? So it's limited, right? I'm kind of stuck where I am unless I try to move it.
Absolutely. Let's go on to the next one, Ben. And I don't think we need to spend a lot time here. The Katie, I think the one question I have on this is, what considerations are driving the decision where you might pursue parallel proceedings?
Less so with changes to PTAB. Sorry, that's like a running theme.
Yeah, it's true.
But I mean, honestly, it's case specific. I think some like overarching factors when you're considering parallel proceedings is like the kind of your perceived risk of the case, whether or not you need kind of additional venues to like foster pressure, whether it will increase settlement pressure if that's something you're going for, and then whether or not you need like an additional venue for like appellate reasons.
Sure. And
And
then,
sorry, just quickly on that appellate point, Katie, I think it's also worth considering, if you've got a trade secret claim, for example, if you don't include a patent claim, that's going to get appealed. If you're in federal court, it's going to get appealed out to the regional circuit court. If you decide to include a patent claim, suddenly it gets kicked to the federal circuit for appeal. So that's another sort of claim strategy with respect to appeals that you said that's worth considering, because for damages reasons, there might be, if you're a defendant, you would prefer to have it go to the federal circuit than a regional circuit court.
Yep. Yep.
Sorry, Mindy.
No,
that's fine. Let's go to the next slide, please. Internal alignment. And I mean, we've been talking about this since, the beginning of this webinar. This is probably really critical. It may be the most critical focus that we talk about. So Katie, when it comes to making sure everyone in the business is aligned, what has worked, what doesn't, and is there a strategy you think that's best? Because budgeting is a really huge part here.
Yes. So two things. With your internal stakeholders, I think you need to get that team in place quickly, like the people that are running the product, whatever, the people that make sense. But on top of that, establish like a chain of authority, right? Like someone who has like the ultimate yes, no. Because what I see a lot is you get a group of, 6 internal stakeholders and they're all willing to listen to your advice, but no one wants to actually make any type of decision. So like establishing like the decision maker, but making sure everybody's voices are heard, I think is really important. And then once you have that team, like your job in-house is working with outside counsel to lay out the facts, lay out the risks, and make the proposed paths forward, right? Make it clear for them so that they can choose a path to take. And that's kind of it, right? It's every time of these are the facts, what we know, what we don't know. Here's where we think the risk is. Here's our options. And then you can say, this is what I'd recommend and why. And then have someone making the choice As far as budgeting, it's really going to depend on how your company structures, how you structure your legal budgets. I typically prefer doing like it's like a fixed fee by phase, so it's a maximum amount billed per phase of the case. I like this because I know, how much my bills are going to be and when they hit. So I feel like internal stakeholders are much more comfortable with that, like knowing what the bill is, when it's going to hit their budget. And then for me, it makes it a lot easier for me to discuss with my outside counsel because I'm not worried about setting up a call or sending an email with questions because, if it's just billed on an hourly basis, I might not do that because I'm scared I'm going to get hit with this giant bill later because I asked about some case, or I asked, for an additional phone call.
Okay, let's go on to the next slide. And I don't think we have to spend a lot of time on this. I think this kind of goes back to the being proactive versus reactive. And the more proactive you are, and the more you partner with the business unit, the better your strategy is going to be. Would you agree, Katie?
Yes.
Okay, let's move on because I know we want to get through the rest of this, Ben.
Yeah. Okay. Managing the litigation. Let's talk sort of going on with what Mindy and Katie were just talking about. How do you manage the different points of time? So early motions. I think the key thing to sort of keep in mind here is that decisions about early motions, whether you move for them, which ones you try and move on, are going to impact both the sort of the leverage or potential risk of the case as well as the cost of the case. And so I think as you're going through and making decisions about whether you want to pursue these options, you need to sort of be thinking that there's a push-pull there. And sometimes moving for an early summary judgment or moving for a preliminary injunction, if it doesn't go your way, that can have a massive impact on the merits of your case or the potential leverage that your case suddenly has if you lose. I've seen cases where early summary judgment motions went sideways, and the order essentially was a roadmap for the other party to defeat the claim. So, Katie, let me ask you this. How are you sort of making a determination about whether you want to move for early motions or motions to transfer, early summary judgment? How are you thinking about those issues?
I mean, it comes back to that initial case analysis where we feel like we're not going to make an early motion. We know we're likely to lose for the reasons you set out, Ben. But like, it really just depends on the case, like where your strengths are, where your weaknesses are, what kind of remedy you can get in the early motions versus summary judgment. I don't think there's like an overarching kind of factor. It's just, you just need to be weighing all those things.
Yeah. Discovery strategy. This is sort of the 800-pound gorilla, and I think everybody knows this is a massive driver of costs of litigation. Katie, what have you found to be best in terms of reining in discovery and trying to get to a place where the costs don't spiral?
See, I think Mindy used this phrase on our prep call and I liked it. It's measure twice, cut once. So figure out your universe of discovery, like put the effort into really understanding where all your documents are, where your custodians are, and do one collection, right? I see like it gets complicated, it gets more expensive when you're doing these multiple rounds of collections. And it's also just disruptive to the business to have to go back and keep collecting. So do your whole collection once, like get your universe. And then talk to your e-discovery vendor. Like I am good friends with our e-discovery vendor, and I am talking to him, constantly about like new tools that are out. There's a new AI tool, I swear, daily that will help you with doc review. So like ask them about it. It'll cut down on costs. Some are better than others, but like I go to those conferences, I listen to those webinars about e-discovery tools because that area is changing a lot with the advent of AI. So that is one area you can really utilize those tools and cut down on your costs.
Oh, great advice. Hey, experts in narrative, we think we can cover this really quickly. I think the one point that I just want to make is a good way to help decrease costs is to not have to change horses during the case. And I think it's really important for both outside counsel and in-house counsel to make sure that they're really vetting not only the experts, but also the people in your company that you think are going to end up being deposed or going to end up testifying, and make sure that they're going to perform well and present well in those instances. I can't tell you the number of times sort of 30B6 witnesses have been identified without a thought on that, and then the person's deposed and their presentation is just sort of awful, and you need to figure out how to solve for that. And changing can end up costing a lot more. So I would just say go into it, and whenever before you disclose anybody, really make sure that you've focused on meeting with them and get insights into how they're going to actually present if they have to. Okay. So cost drivers, these are the key cost drivers. I think we've all sort of talked about them and we all know what they are, so we'll drive past. We talked a little bit already about the settlement windows. These are the main ones when it comes up, so I don't think we need to belabor that. Reaching resolution. Okay, last module.
Okay. So this is all, we've all been leading up to this, and a lot of this, you're gonna be surprised, is the same advice that we've already given. But I guess, Katie, one thing to ask you on this, is there a common resolution lever that you think outside counsel frequently overlooks?
It's what we mentioned before, right? It's all those like business levers. So outside counsel should be asking, like, is there a business solution here, right? Like, can we get creative? Is there something outside of monetary settlement or litigation? Like, what else is there? Because oftentimes there is something. So I think it's just figuring out what it is.
Okay, let's go to the next slide, Ben. So these are the three biggest mistakes that we see happening in cases. Honestly, I cannot tell you how many times I'm in the middle of litigation as outside counsel and my client says, but we've already spent X amount of dollars, so we have to keep going. And I will say, and this is especially true in trade secret cases, and especially trade secret cases where you obtain injunctive relief, like the damages that you might get, even if you go to trial, may not be that large. And they may not even be enough to pay your attorney's fees. And I know that a lot of clients focus on, like, I at least want to get my attorney's fees out of that. And you really have to kind of do this careful analysis and figure out how much you're going to spend going forward to recover what the attorney's fees were 6 months ago. And what about any other mistakes other than these that you see, Katie?
Not really. I mean, definitely, people get scared, they act quickly without thinking. It's your job to get involved, make sure that you're counseling them from the beginning. And then I think going back to what the point you just made, Mindy, is when you're in-house and you're advising your business people, you need to be really realistic about your risk assessment. Like, you should not be giving them the rosy picture of, like, we're going to win this trial and win all this money. Like, it should be very realistic and very conservative, right? Like, you want to under promise, over deliver. Like, so they should be thinking, okay, I'm going to get hit for 10 million. And when the verdict comes in for 2, they're happy. Like, I mean,
Absolutely.
don't overinflate it, but like be conservative when you're doing these risk analyses.
Yeah. Let's skip the next one, Ben, and just go to the where companies most often get it wrong. And just really quickly, because we're almost out of time, these are all exactly the points that we've been hitting on and emphasizing today. You've got to be aligned with the business, you've got to be aligned with outside counsel, and you've got to plan strategically ahead. And these are the mistakes that can cost not just money, but sometimes in lawsuits it's more than just money, right? So the more you can plan ahead and align, the better your litigation is going to go. I think we can just go. I think we've covered that. So let's just go to the last slide.
Don't have time for questions. If anyone is interested, as I said, this is the first of the 5-part series. Here are the additional 4 presentations with the dates. And so if you're interested in coming, we would appreciate that. And I just want to thank you for coming and being here with us, and to Mindy and Katie for making the time, and for the ACC to helping us put this together. I hope everyone thought it was beneficial.
Thanks so much.
Thanks, everybody. Good day. Bye.